Pooh Shiesty is trying to come home before trial, but prosecutors just answered his bond request with something much stronger than a regular objection. They brought records, and one of those records is an impact statement from a person identified as CW, who says he is a victim and survivor from the January 10th incident. This is the part that makes the bond fight feel different, because CW is not talking like a lawyer. He's talking like someone who does not want the judge to take a chance. In the statement, CW asked the court to keep Lontrell Williams Jr, better known as Pooh Shiesty, held with no bond. He says he has safety concerns for himself and his family. He says he is a retired police officer, and according to the statement, he believes Pooh Shiesty knew that before the incident. That detail matters, because CW is basically telling the judge, if that did not stop him before, why would bond conditions stop him now? Now, to be clear, this is still an ongoing federal case. Pooh Shiesty has pleaded not guilty, and these allegations have not been proven at trial. But bond hearings are not trials. Bond hearings are about risk, and prosecutors are trying to make the judge feel that risk before anything else. CW says he is the only alleged victim in the case who lives in Texas. He says he fears Pooh Shiesty or someone connected to him could reach him or his family if bond is granted. Then he says something even more personal. He says since the incident, he has found himself watching vehicles passing by his home. He says he has young children, and because of that fear, he has limited their ability to go outside and enjoy normal activities. That is not just paperwork, that is emotion. And that is exactly why prosecutors attached it, because Pooh Shiesty's lawyers are asking the judge to trust a strict release plan. But prosecutors are asking the judge to look at this statement and say, what if the risk is too high? And that is only the first layer, because after the victim statement, prosecutors brought out the records they say show why release conditions already failed once. This is where the bond fight gets serious. Pooh Shiesty's lawyers are saying he can be released under strict conditions: home confinement, GPS monitoring, drug testing, no contact with alleged victims, restricted travel, heavy supervision. On paper, that sounds like a controlled plan. But prosecutors are saying the court already tried rules, the court already tried monitoring, the court already trusted conditions. And now they are using his own supervision records to argue that the judge should not do it again. That is the strongest part of the government's argument. They are not just saying, we think he is dangerous. They are saying, look at what happened while he was already under rules. That is a completely different message. Because in court, the judge is not deciding whether Pooh Shiesty is guilty today. The judge is deciding whether he can be trusted outside while he waits for trial. And prosecutors are trying to destroy that trust with paperwork. They attach home detention conditions. They attached incident reports. They attached sign-in and sign-out logs. They attached a location chart. They attached text messages. They attached a victim statement. In other words, prosecutors are trying to build a full picture. Not one mistake, not one misunderstanding, a pattern. And that word matters because judges pay close attention to patterns when someone is asking for release. The defense wants the judge to focus on what could happen now with stricter rules. The prosecution wants the judge to focus on what they say already happened before. That is the battle. Future conditions versus past behavior. And the first document prosecutors want the judge to remember is the home detention paperwork Pooh Shiesty signed before this new case exploded. Because that paperwork says something that may be hard for his defense to get around. Before this new case became a national headline, Pooh Shiesty was already under home detention rules, and the paperwork is clear. The document says home detention is a privilege. It says that privilege can be revoked. It says violations or conduct showing disregard for the rights of others can be enough to end home detention or program participation. That line is important because prosecutors can use it to say he knew exactly what was at stake. He was not guessing. He was not confused about whether the rules mattered. The condition said he had to live at his approved residence. He had to conduct himself lawfully. He had to answer calls from staff. He had to accept visits from supervision personnel. He had to return for reviews. He had to submit to testing. And he had to remain at his residence unless he had specific permission to leave. Those rules matter because Pooh Shiesty is now asking for another version of supervised release. And prosecutors are basically saying, why should the court trust another release plan when the earlier plan already had rules? That is the problem. The defense can argue that stricter conditions would work, but the prosecution can say the old conditions were already strict enough to test whether he would follow rules. And according to the government, the records show he did not. Now, that does not prove the new criminal charges. A home detention issue is not the same thing as a conviction in a federal kidnapping case. But for bond, it gives prosecutors a weapon. Because bond is about whether the judge feels safe letting someone out. And the government is trying to make the judge feel like the answer should be no. Then they point to the alleged violations. And this is where the paperwork starts looking bad. The incident reports are some of the most important documents in this entire bond fight. Because they do not sound like gossip. They sound like supervision records. One report says that on January 10th, staff noticed Lontrell Williams sitting in a car in the parking lot of his apartment complex. According to the report, he was told to get into his apartment. Then, about half an hour later, staff allegedly noticed him at an unapproved address near a shopping center with Best Buy and Magnolia Electronics. The report says he was called and told to return home immediately. That date matters. January 10th is also the date connected to the alleged Dallas incident. Now, that report by itself does not prove the bigger criminal case. It is about an alleged unauthorized area violation. But prosecutors can use it to tell the judge something simple. He was already supposed to be controlled, and look what the records say happened. Then there are the testing reports. One report says he was asked to provide a urine sample in November, but the sample was allegedly cold and outside the expected temperature range, so staff wrote it up as a refusal. Another report says that in January, he was contacted about a scheduled test, but did not report after saying he could not secure transportation. Another report says that in March, he was told to report for a test, asked to come the next morning after mentioning transportation issues, and then allegedly did not show up. Again, these are not trial verdicts. But prosecutors do not need a trial verdict to fight bond. They need enough to argue risk. And when you stack alleged unauthorized movement with missed testing issues, prosecutors can argue this is bigger than one incident. They can argue the court already had warning signs. But the defense is not going to see it that way. They can say transportation problems happen. They can say technical violations should not decide a person's freedom. They can say supervision can be tightened. That is why this case is so heated, because both sides can look at the same paperwork and tell two completely different stories. Then come the text messages. And this is where the case starts feeling less like paperwork and more like a timeline. The messages show people asking about shoot days, addresses, and locations. Some messages ask, what day is the shoot? Others ask for the address. Some responses send Dallas area locations connected to studios, gyms, shopping areas, and filming. There are references to shoots, there are addresses. There are timestamps, there are travel arrangements. There's even a message about a shoot beginning at 1 p.m., lasting about an hour, and including a $2,000 shopping budget. Now, on the surface, that can sound completely normal in the music world. Rappers have shoots, rappers go to studios. Rappers move around for content, business, clothes, videos, interviews, and recording sessions. That is the defense-friendly way to look at it. But prosecutors are likely looking at it differently. They can argue these messages show planning, coordination, movement, and repeated location activity while Pooh Shiesty was under supervision. That is what makes this evidence dangerous in a bond fight, because a text message does not have to prove the whole case by itself. It only has to fit into the larger picture prosecutors are painting. Home detention rules, alleged violations, location logs, and text messages, victim fear, all of it together. And that is exactly how federal prosecutors build pressure, not with one document, with layers. And the more layers they stack, the harder it becomes for the defense to make the case sound simple. But there is still a major question. Were these normal entertainment movements? Or do these messages help prosecutors argue supervision was not enough? That question leads straight into the movement logs. The movement logs might sound boring at first, but in this case, they could be one of the keys to the whole bond argument. Because the logs show approved passes, actual locations, times, and movements. That gives prosecutors something very important, a timeline. And once prosecutors have a timeline, they can compare it to messages, locations, incident reports, and witness claims. The records show different Dallas area locations over time: Legacy West, Target, Luminous Sound Studio, fitness locations, malls, Prophecy Film Studio, Sneaker Haven, other addresses connected to shoots and movements. Some dates in the chart say there was no pass. Other dates show time windows and locations. That matters because prosecutors can ask the judge one question: was he where he was supposed to be? The defense can argue that many of these movements were approved, normal, and explainable. The prosecution can argue the records show why monitoring does not solve everything. And one detail in the chart stands out. There is an entry that says on February 6th, he got into a car accident around 9 p.m. on the Dallas North Tollway with someone trying to track down the report. Now, without the full report, that should not be overhyped. But in a bond video, it is worth mentioning because it shows how messy the supervision timeline may have become. And that is what prosecutors want the judge to feel. Not just that there were rules, but that the rules became difficult to control. That is the government's argument in plain English. They are saying, if we could not rely on the earlier conditions, why should the court rely on new ones? But there is one argument Pooh Shiesty supporters are going to keep bringing up, and it might be the defense's strongest public point. This is the part fans are going to argue about, because Pooh Shiesty is still fighting to get released, while other people connected to the case have reportedly been granted bond. And that creates the obvious question: why him? If this is one federal case with multiple defendants, why are prosecutors fighting so hard to keep Pooh Shiesty detained? Supporters are going to say it does not feel equal. They're going to say if other co-defendants can be trusted with release conditions, then Pooh Shiesty should at least get the same chance. That is a real argument in the court of public opinion, but prosecutors are not looking at it that way. They are trying to separate him from everybody else. They are looking at his alleged role, his prior case, his home detention paperwork, his alleged supervision issues, his movement logs, the text messages, and the victim statement. In other words, the government is telling the judge, do not compare him to everyone else. Look at his record by itself. That is the pressure point. The defense wants fairness. The prosecution wants separation. And the judge has to decide whether Pooh Shiesty should be treated like others who got bond, or whether prosecutors have shown enough to make him different. That is why this part is so important, because if the judge agrees with the defense, Pooh Shiesty could get a major win before trial even begins. But if the judge agrees with prosecutors, it sends a message that the court sees him as a different level of risk. And that would be a serious setback, especially because trial is not happening tomorrow. This is the part fans are going to feel. If the judge says no, Pooh Shiesty may not be waiting days or weeks. He could be sitting for months before a jury ever hears the case. That is why the bond request matters so much. His lawyers are not just asking for convenience. They are asking the court not to keep him detained for a long period before trial, especially when he has not been convicted in this new case. That is the defense's human argument, but prosecutors have their own human argument. They are saying the longer this case goes on, the more important it is to protect alleged victims, witnesses, and the community. So the delay cuts both ways. For the defense, delay means unfair time in custody before trial. For prosecutors, delay means more time where they believe risk has to be controlled. That is why this ruling could shape everything. If Pooh Shiesty gets released, the public conversation changes immediately. His side gets momentum. Fans will say the judge finally gave him a chance to fight the case from outside. But if he gets denied again, prosecutors get the stronger headline. They can say the judge looked at the bond request, looked at the records, looked at the victim statement, and still decided release was too risky. That would not mean he is guilty, but it would mean the court was not convinced that conditions were enough. And in a case like this, that matters, because sometimes the biggest battles happen before trial ever starts. So now this whole bond fight comes down to one uncomfortable question. Did prosecutors just show the judge real warning signs, or are they stacking every technical issue they can find to keep Pooh Shiesty locked up? That is what makes this case so debatable. When people see the victim statement, some will say the judge has to take that fear seriously. When people see the incident reports, some will say the records show why release conditions are not enough. When people see the text messages and location logs, some will say prosecutors are building a pattern, but others will see it differently. They will say shoot locations are normal in the music business. They will say transportation problems should not decide whether someone gets bond. They will say if other defendants are out, Pooh Shiesty should at least have a chance at strict release conditions too. That is why this case is not simple. Pooh Shiesty is asking the court for trust. Prosecutors are answering with records. And now the judge has to decide which side is more convincing. Can Pooh Shiesty be trusted under stricter conditions than before? Or did prosecutors show enough paperwork to make another release plan too risky? That next ruling could tell us a lot about how the judge sees the case before trial. So I want to know what you think. Are prosecutors using real warning signs? Or are they using every possible record to make sure Pooh Shiesty stays locked up? Drop your thoughts in the comments. If you want the next chapter when it drops, subscribe.